know it's really chilly in here. I think next year we're going to have the CSF Foundation bring blankets as door prizes. Bring your own. I apologize. We've been trying to fix that, but it's not happening for us. I'd like to introduce Chiari Snyder. Chiari has been a frequent speaker here at St. Louis Children's Hospitals, talking on a variety of legal topics to our population. She has a wonderful reputation here, and when I had told someone we were going to do this event, they said, oh, you must have Chiari come. So we're grateful to have her. She is an Assistant Attorney General for the state of Missouri and has served on a number of different advocacy groups. She has been on boards for various organizations and represents a number of local charities. She was named to 40 professionals under 40 of St. Louis Charles, and lives here in St. Louis with her husband and her 4 active sons who range from 11 to 17 years old. So if you will welcome Chiari, thank you for speaking.
Thank you. In my bio, I guess I haven't given a new one because now they're 13 to 19. So that's a 2-year-old bio. That's okay. I wish they were still 11 to 17 because the older they get, the less cool I become. So, but yeah, I hope so. I do limit my practice to estate planning, a lot of special needs or disability planning, probate, elder law, trust, and administration services. So that's all my entire firm does. And I'm a firm believer that I do get involved sometimes with some of the charitable organizations I represent on the litigation side, but I see that if you plan in advance, you can avoid that. So my goal with the clients I meet with is to have them plan in advance so that we're not in front of a judge or a commissioner, whether it be for a guardian conservatorship or a dispute after someone passes away. So especially if you have a child or another loved one, sometimes it can even be a grandchild or a sibling, it's important to look at this holistically, because a lot of times it's a difficult discussion to have, to your siblings or your parents. If Johnny by any chance could ever get something when you die, by the way, you can't just leave it to him. So that's not always the conversation you want to have. So I help my clients sort of wade through that, not only planning their own estates and dealing with things for their own child, but to go ahead and educate their extended family and friends, because there's a number of ways that someone who has a disabling condition or suffers from a disabling impairment could unintentionally inherit assets in a way that would make them ineligible for some services they may be receiving, and that's really crucial that doesn't happen. So the first question I always ask everybody is, do you have a plan? And it is amazing. Anybody over 18 really needs, at a bare minimum, a healthcare directive and a power of attorney. And I know I just dropped my son off at KU yesterday, and he, when I told him that he needed to do this, he thought it was extremely morbid. And I said, well, just bear with me. I said, you don't even have to put me on it. You can put it whoever you want, but you got to name somebody, because I don't want to be in front of a judge trying to get an expedited guardianship conservatorship to authorize emergency non-life-threatening surgery, because that's those are the calls I get from people. And I say, well, it's going to take about 60 days. That's not the answer you want when someone needs sort of an elective surgery. In Missouri and most states, doctors will perform emergency life-saving treatment, but anything that needs consent, if someone is over 18, there has to be somebody that legally can consent for them. So that is something you don't think about. So for folks that have children who may not have capacity, and again, when I was in getting ready for today, I looked up the syndromes that we're talking about and some of the different the scales, I guess, of severity. What I found very different from maybe some of the other groups I've spoken to is there's such a wide range. For instance, it seems like I've heard a couple of anecdotal conversations out here about people's children who are in PhD programs or getting their masters. Sometimes when I speak to groups, we're talking maybe at a different level where, their child will never be above have the cognitive ability of a 5 or 4-year-old. So sometimes those discussions are a little different. So since we have very wide range, and I don't really know all of your children or who you're here to receive information on behalf of, I'm going to kind of look at all of the different things that could come up, because for some of you, some of this may not apply. For some of it, it applies to everyone. In other words, everyone should have a will. And again, only 40% of people have a will, which to me is just amazing, but that's all I do. So, of course, I'm jaded. And 17% of Americans have a trust, which again, I would even say 10 years ago, it was one of those things people would come to me and say, I don't need an estate plan. I don't have anything. Well, everybody needs an estate plan, and what you don't know is whether you live in Missouri or another state, you do have one. You may just not have written it. The state of Missouri wrote it for you. So if you don't have documents in place, even simplistic ones, you do have an estate plan, and we'll kind of get into some of the defaults and whether those defaults work for you or not. First of all, if you have a minor child right now, a will is the only document that you can technically advocate to the judge or give your list of preferences of who you would want to serve as a guardian or conservator in the case that you became disabled yourself or deceased untimely or unexpectedly, which again, when I meet with people, 99% of the time, I'm not going to die for a long time. Nobody plans on dying unless they are suffering from a fatal pathology of some sort or disease. Now, those folks, those are very different conversations when I meet with people after they've had a diagnosis that they know that they're terminal. But most of the folks I meet with are just coming in to do what I would call run-of-the-mill estate planning, and we start talking about this, and they think of this as something they need in the future, as opposed to a living, breathing plan that will change over time. But if you have a child with a disabling condition or a disease or a diagnosis that could affect their cognitive abilities in the future to make their own decisions, then there may be some additional planning that you would need to do that you wouldn't need to do maybe for some of your other children. Now, if your child is going to be able to get a master's, if your child is going to get their PhD, you may not have to do special planning for that child. So some of the special planning that we talk about, and I know in the community, the active person language and things, you'll have to forgive me if I ever slip back into some of the old vernacular, but the laws are still written differently. So there's not used, the laws that I deal with every day don't deal with the active person way of speaking about someone with a disability. So again, I have to apologize in advance if I slip into saying something that's not PC. Know that it's just because the laws are written in that format, and so that's the, you do something for 25 years, I guess you get I'm kind of an old dog, so the new tricks are coming. But when is special planning required in an estate plan? Really, if you have someone who could qualify for public governmental benefits at some time, maybe not now, maybe in the future, maybe you're unsure, then we can put in sort of springing planning in that case. Because a lot of times when your children are younger and you're trying to figure out what is their level of, what's the level that this particular syndrome is going to affect my child? What adaptive technologies are out there. So in other words, you might have a child right now that you're pretty certain couldn't be self-supportive. But by the time your child is 19, it sounds like with all of the research going on and things, you don't know. The medical community is changing so often, and no matter what group I'm speaking to, there's really no absolute certainties anymore. Even when I started practicing law 26 years ago, the things that I'm seeing now, we're not even on the spectrum of possibility back then. If you had a child with a certain diagnosis, you may as well just have put them in a room and forget about them 25 years ago, and that's how planning was done. So as attorneys, that's how we wrote those plans, assuming that someone would be institutionalized or they would stay at home until mom and dad were too old to care for someone, and then we would figure it out at that point. People are much more proactive, and there's so many more group housing situations and adaptive technologies and assisted living type situations for a variety of medical conditions. So what I found with each family is it's different. So even if I meet with one family, say, that came out of this group, and I meet with a second family from this group, my guess is their estate plans would look completely different because their children is different, their child is different, their family situation is different, where they live, what's available to them, what services are available, and how different technologies come out and how different medical treatments might impact their child in the future, might change the course of what we think that child's future looks like. So again, it's not like an estate plan. You think of it as a product you go buy, you stick it in a drawer, you put it away. That's really not estate planning. Estate planning is sort of a continuum of legal documents that you start with at some point, and then you look at every 3 to 5 to 10 years and adapt and change and revise those documents as your family situation changes. And there's many, many different things that can come into play. I have clients who call me. We say to call our office every 3 to 5 years. I found that most clients who are calling me now did their initial estate plan between 2004 to 2006, just anecdotally. So that tells you most people are waiting over 10 years. So it's usually like all their children were young and now they're all in college, or they're married, now they have grandchildren, or they're retiring. There's certain milestones that people tend to call someone like me. You know, it's not the kind of thing you're just dying to see your estate planning attorney, no pun intended, but it is one of those things that we tell clients, call our office at least, and we'll tell you if any major laws have changed. So, as you may know, if you've dealt with any governmental programs where you need to qualify, the definition under the Social Security law is the one that is adapted or adopted for most public governmental benefits to qualify. That's your entree. And so you have to meet the definition of disability, which is designed to last for 12 or so months, or 12 plus months, or be permanent or fatal. It also has to impact their ability to earn a living wage. And I could get into the details of the 6% above poverty level and all of those kind of things, but I'm not going to bore you with that. If you haven't had to deal with this definition yet, you're lucky, and hopefully you never will, because Social Security disability laws, the laws themselves haven't changed, but I found that the standard that's applied, I don't practice Social Security disability. I have other folks I recommend those clients out to when they're having issues with this. But what I found in my practice is everybody gets denied. And then I think, are the only thing I can imagine, and again, I used to be with the government, so I can say this, is that only a certain percentage of the people will appeal, and only a certain percentage of those people will follow up and appeal if they get rejected again. So most folks are getting denied at least the first, if not the first 2 times that they apply. And that's a sad state of affairs, but it does show you that with limited resource dollars out there, they're trying to, I think, restrict the pool to the people who need it the most. That doesn't always help, though, if you have someone who legitimately needs to qualify as an entree into some public governmental resources that would otherwise help them with their daily life. So again, whether you have a child who's very young, whether your child is 30, in your estate plan, you're going to want to address that child's needs. And again, I would always caution you that if you addressed it 5-10 years ago, that may not be the same as 5 years from now. So you do want to keep looking at your plan and reaching out to your advisors. And it could be a team of advisors. So a lot of times I'm working with not only someone's CPA, but also their financial advisor. There's a lot of ways that some of the financial professionals can help leverage funds so that, for instance, if you're providing a large amount of the care that your child needs, or some of the extra things that aren't offered where they need assistance, but no governmental program will pick that up, how is that going to be handled if you are no longer able to provide those services? So in other words, if you have a child who can't drive, maybe cognitively they're fine, but they won't be able to operate a motor vehicle. Depending on where you live, there may or may not be public transportation options that are available. Some are not wheelchair accessible, or if they are, there's only a limited number of spots on the bus that accommodate a wheelchair. So if you're not the first one to the bus stop, I've heard that from clients, sometimes you can't get to work on time. And so those kind of things, you have to look at, how am I going to pay for that if I can't do that? Because what I find with a lot of my families with children with disabling conditions is that they're providing a whole lot of services. And until you really go down and kind of itemize it, people don't realize how much they're doing, because you've just always done it, right? You're the parent, that's your job. You're very in tune with what your child needs, but you don't think about, gosh, if I get struck by the proverbial bus today, who's going to step in, who's going to provide all these services, and more importantly, sometimes how are we going to pay for that? And so a lot of times I'll bring the client's personal financial professionals into these meetings, because we might look at ways to leverage that in the future. So, and we could be talking 20, 30, 40, 50 years in the future. But we do want to always look at that. How are these things going to be covered in the event that something would happen to a parent? The other thing that I do want to talk about is making sure that your medical records do reflect the nature of your child's disability. And I know the prior speaker spoke with that as far as keeping records for educational purposes. It's the same for receiving public governmental benefits later. So there are certain conditions that, for instance, certain programs, I should say, where if you're disabled under the Social Security Act definition before age 18 or before age 22, that you have an automatic entree in. The problem with that is when the parents come to me and the parents are 80 and the child is 50. So we're looking at documents where they don't have any documentation. This child was born with this condition potentially. Maybe it was something that was developed later in life. There's certain conditions I know for, like, especially young men, it seems like that hit in the late 20s. Sometimes they have missed the window. But for someone who had that condition before they were 22, sometimes it's hard to prove. So you do want to make sure that you're documenting it in your annual, whether it's just your pediatrician, whether it's a specialist, whoever you're meeting with, and getting copies of those records routinely. Because I know with medical records, it's sort of like in my office, storage is an issue. We have, I'm trying to go paperless, but it's very hard for me. I still like my paper. But in the medical profession, now, as I'm sure when you sign in places, they'll give you an iPad, and the doctor's, got his little thing, iPad or whatever their tablets are, where they're putting things in, and I know things magically show up at Walgreens and stuff. That's pretty. It's pretty cool, but you never know is you don't have copies of what they're writing down. So are they writing down, well, yeah, my annual checkup, and this is what I need to do, and here's the script you need, and here's the occupational therapy prescription or the PT prescription that you need, or whatever it is? Or are they really writing down, yes, my child can't really do this. This is what they're having difficulty with. And especially when you're not with a specialist, if you're dealing with annual routine physicals, you want to make sure that all those doctors' records have the same information in it. Because when I find that people are fighting with governmental agencies to get onto programs they need, to get waiver programs that they need, some which are funded right now but are not funded at other times, so you get grandfathered in. It's very important that at the time that a particular program has funding, if you're in the queue to get that funding, you want to make sure your medical records will document the fact that your child had this disabling condition prior to reaching age 22. Because for most of them, there's a few that are 18, but most is going to be 22. So again, you want to make sure, especially if your child is in that 15 and up range, you want to start making sure that you document things that, you've been seeing this doctor for years and that you think they know your child, but you don't know that they're putting that in their notes. And not to second guess the medical community, but it is one of those issues that when the government's looking at it, they don't really care, oh, well, we were talking more about other things or research during our meeting. They want to know what's in that doctor's notes. And again, because the doctor has been seeing you maybe since your child was born, they're not going to put every year certain things in there and at certain times forms. You may not have copies of them, so it is a good idea to request those records every once in a while. Some of the programs that we deal with specifically when we're deciding whether or not we need special planning in what I would call, again, the run-of-the-mill estate planning documents is what kind of program could your child want to be on or need to be on or qualify for. SSDI is Social Security Disability Income. So you hear about that quite a bit. That could be someone who is fully disabled before, again, age 22, that could qualify either on their own work record or on a parent's work record. And generally, with most of my kiddos, now not always, but sometimes we're looking at qualifying on a parent's work record. So say the parent has retired or the parent has become disabled themselves, then a qualifying individual could qualify on a parent's work record that has the requisite number of quarters of paying into the system, that then it's an entitlement. So it's not needs-based, it's not income-based, it's not asset-based, it's just if you've paid in, you get that benefit. So that benefit is the least restrictive benefit. But again, you'd have to be able to prove that you had that disabling condition before age 22. And what I find a lot of times happens is that doesn't come up until mom or dad retires. So when mom or dad retires, and that age has been getting slowly and slowly older, so say somebody's retiring at 70, you may have a 40 or 50-year-old at that point who would qualify that never qualified before. So before they were on SSI, which is the next thing we're going to talk about. That's a needs-based program that you don't have to have qualifying quarters on a work record. You just qualify because you have a disabling condition that keeps you from making a living wage, usually, but it's a lower income. It's a lower income stream. So say and I should have these numbers memorized, but say it's $774 is the maximum. The most you can get on Social Security disability income is going to be much higher. So sometimes you'll have somebody who's been on SSI for years because they don't make enough to live out on their own. So they qualify for SSI, which is supplemental security income, which again has that 700 threshold. When I first started practicing, I think it was 500, so that tells you it's gone up quite a bit. But you could jump to a much higher benefit. So maybe you get 1,100, maybe you get 1,400 if you were able to qualify on a parent's work record. But that's when those old medical records really come into play, because once the state agency has found that you qualify for SSI, they've made a finding of disability. They may not, though, have made that finding until you applied. So a lot of folks don't apply for SSI until their child is 26, 27, 28, sometimes not for a long time, because they feel like they can take care of them. A lot of times it has to do with where mom or dad works and how their health insurance works. There are a lot of, now I take that back, there are less and less employers now who automatically will let you keep a child with a disability on your health insurance indefinitely. That didn't used to be the case. So early on, say even 10, 15 years ago, I had folks that, it wasn't until mom and dad were retiring that, oh my goodness, how are we going to keep health insurance for Junior? Because now I qualify for Medicare. I'm retiring and I'm of the age where I can get Medicare, but my child can't. So getting on either SSI or SSDI is their entree into getting on Medicare and potentially Medicaid. So Medicaid covers some of the differentials, like the copays, the deductibles on Medicare. And so I'm not going to get too mired in those details, because some of your children, this may not even apply. But these are the kind of things that when I'm meeting with a family and talking about the kind of documents you need, we're looking at, do you have a child that this is ever going to become an issue for? Because if it is, then we need to plan for it. And if we're not sure if it is, we need to plan for it. You can always take that planning out of your documents. You can't necessarily put it back in once you have dementia, or once you're in a coma, or once you're deceased. So you need to do it while you're alive and competent. And believe me, it's difficult when I'm talking to people, because they keep thinking, well, this is planning we can put off. Yes?
I have a question about just the whole list of benefits.
Mm-hmm.
What happens if you have a child who has a condition where their lifespan is not determined? Like, I have a nephew who just was diagnosed with brain cancer last month, so they've only given him a certain amount of time. But how long does it take to apply for any of these benefits and to receive them?
Well, most of the benefits that I'm talking about right now, if somebody was extremely low income, there may be like SNAP or food stamps. There might be some things that they could get that would help offset, because if they have high medical costs. They could get them on Missouri Medicaid for children, so they could get health insurance generally through that if the parent doesn't have insurance. So that some of those could be immediate. Most of the benefits we're talking about here are things that the child would need when they become an adult. So unfortunately, if the prognosis is such that they may not live into adulthood, some of this may not apply. However, it would be important to make sure it's all documented, because sometimes the treatment for things like tumors or cancer, they may end up being fine and living, but then have some cognitive impairments, which later would require them to be on some of these programs, because maybe although we fix the cancer, now we have someone who maybe can't concentrate for extended periods of time or things like that. So we might need to get them some supplemental income in their adulthood.
He's 23, so...
Okay, so he's already older.
Yeah. So would they apply for the SSI or the SSDI or...
It depends, I guess, if he has the requisite number of qualifying quarters, and so that's something I can get you that information if you want. There's a whole table. It's kind of complex, but if he's worked on his own, he may have enough to qualify on his own work record. If he had, you said it was a brain cancer.
Yes.
Did it start before he was 22?
Well, the tumor has been there for 4 years, but it wasn't diagnosed until a car accident, and they did a biopsy in July, and that's when they found that it was cancer.
Well, so in that case, if they can prove that the tumor was there for 4 years, they should be able to qualify on their parents' work record. So that would be one that they may fall into that kind of a narrow niche where they could probably get the higher benefit if the medical records would support that. And again, what I'm seeing, unfortunately, though, is they might get denied the first time and have to get an attorney involved for an appeal of that. But that's what they should probably try for, because SSI is going to be a much lower benefit generally. And I keep pushing this back in to get to the cursor. So what are the common mistakes most people make? They either don't plan at all because they think it's not going to happen to me, or I've got plenty of time and I really don't want to go meet with an attorney, talk about morbid topics like death and dying, and I definitely don't want to spend the money on it. So that's something that most people do. There's also a lot of the whole idea of, well, I'll just kind of put my other child's name on everything and they know what to do. If something would happen to me and I have 2 children and one child is potentially going to have a disability that reaches into adulthood that's going to keep them from being able to support themselves, I'm going to give everything to my other child and they will take care of Susie or Johnny, which is I can tell you all the reasons that will never work and is a horrible idea, but I will say most of the people that come to me have that kind of plan in place. They also say, oh, well, I'm going to avoid probate. John down at the post office told me to, put my kids' names on everything as POD or jointly titled with adult children. Again, horrific, horrible ideas for a variety of reasons. And a lot of times it's actually, like I had alluded to earlier, talking to family members. Because what most people don't realize is, say you have parents or siblings. For instance, I have one brother, he has no children. My guess is, and again, I've never talked to him about it, but my guess is if he got hit by a car today, that his will probably says what most people's does. He might give it to certain people. He might say something to my sister, and if she predeceases me, to her children. Well, that's great, because people assume that, well, if something happens to me, say I die, that he'll go change his documents then. If I had a child with, in the legal community, the term special needs. So in other words, we need some kind of special planning there to protect their entree into benefits. But if I hadn't told him about that and reminded him about that, his documents might have that plain vanilla language that 100% of most documents do. that says it goes to my children in equal shares. There's a legal term called per stirpes, that means by right of representation, and each of my kids would get a half of whatever I was going to get. Well, that's all well and good unless I have a child who's on SSI. They're going to get kicked off SSI even if they get a relatively small bequest. So I'll have someone give me a call and say, my child is, been in SSI. It took us 3 years to get him on SSI. We're now on Medicare. We've got Medicaid. So we've got all these things working, all these components. We're on a Sarah Lopez waiver. We've got it all. And then they inherit $12,000 or $30,000. And the whole thing just falls apart because those are need-based benefits. And once you have over, depending on the benefit, it's $999.99. It could be $2,000. It could be $3,000. That child automatically loses their benefits. Some benefit programs, we have a month where we could try to spend it down if we could, without losing full benefits and having to start over again. So that's the key. I get those calls. In fact, I've got a trust I'm drafting tomorrow because someone has a relatively small, yes, $30,000 is not small, but when it comes to taking care of someone for a lifetime, that's a small amount of assets. So I've got $30,000, and that's why I picked that number because it just happened. Some distant relative had died, left this child $30,000. That was the share how it ended up. And I've got until Monday to get a trust made so that I can get it down to Jeff City, get it approved, and get the Emmaus Homes, who's holding it temporarily for us, dumped over into an account before the first of the month. So those are the kind of situations you really don't want to have happen because I can tell you it's going to be hard to find a lawyer who will do that. I'm kind of a sucker, so I tend to do that stuff. But again, that's just a recipe for disaster because this particular child, if they lost Medicaid, and they would lose their Medicare. So in that case, that's the bigger issue really is health insurance. So it's not maybe the $500, $700 of SSI they're getting. Yes, that helps and that makes a difference. But it's the health insurance. If you don't have health insurance, how are you going to get that expensive treatment you need? How are you going to get, I have clients who when they tell me if they had to go out and buy some of these drugs, what they cost, it's shocking to me. I can't even comprehend that. So if they don't have the insurance to pay for it, they're not going to be able to get by at all. So again, making sure that everybody knows that, hey, this is a real concern because most people don't expect people to die in the wrong order. And again, since this is all I do every day, I will tell you people die in the wrong order all the time. I have elderly clients who come to me because I do elder law as well. We've got what we call the sick spouse and we've got the well spouse. And we're doing all this planning and then the well spouse has a heart attack and dies. So you can never plan on anything happening in a certain order. So with an estate plan that's really done correctly, there's all this if and but planning. What if someone's alive and competent? What if they're not competent? What if they have a disabling condition? What if they have Medicaid? What if they're on Medicare? What if they have a certain waiver program? What if they're in a group living environment that requires them to have less than a certain amount of assets in their name or less than a certain amount of income? We have to plan for all of that in advance. And then again, just updating that plan as situations change and as the laws change. Okay, so now it's not forwarding. Okay, good. So again, this is the one I talked about, the disinheriting someone who has a disabling condition. Yes?
I was just curious, so when you're saying, so the 30,000, so would you recommend that families not leave their children behind, or by putting it in that trust, it makes it to where they don't disqualify?
Well, that's exactly where we're going. What are the options? Because if they get $30,000, there's something called vesting. So in other words, if I die today, the second I'm dead, certain things vest. So in other words, if I had, say, a child's name, which a lot of my elderly clients, they have their children's name on all their assets. Horrible idea, by the way. But if they do, the second I'm dead, whoever's name is on that account with me, it is automatically theirs. There's nothing that has to happen. There's no magic. They may have to from a practical perspective, wait until my death certificate's issued to take it to the bank to get it all paid over to them, depending on how it's titled, or if there's a beneficiary designation. But what you don't want is anything to vest. So you want to have contingency plans in place so nothing technically vests, so that we have time to do things. So this is, for instance, something someone will do. They'll say everybody except child X, or grandchild, or my sister's child is not going to get any assets when I die. And then again, that's the example I gave where they say, but oh, my other kids or the other cousins, they know what to do and they'll make sure Susie's taken care of. Well, that doesn't always work very well, and I will tell you, I've been with a lot of families in those situations, and I can't think of one in 26 years that actually worked exactly like it was supposed to. Not to generalize, but you're always going to have like the good kids, and then you've got the bad kid. And maybe it's not the bad kid, but it's the bad kid's spouse who says, well, legally that money's it's yours. It's really not Susie's. And even though mom said you were supposed to split it with Susie, you really don't have to. So you've got that whole dynamic. Then there could be gift tax consequences. So in other words, most people don't realize there's only a certain amount of money you can give somebody without reporting it to the IRS every year. Now, right now it's $15,000 a year, and if they're married, that would be $30,000. So that's a lot of money. But for instance, if somebody died and say they have $200,000 worth of life insurance, you don't have to have a lot of assets and still be worth quite a bit when you're deceased. I'll have clients who have $1 million life insurance policy. So they think, oh, well, I don't have anything. Well, no, you do. You have this huge life insurance policy. So if you had to get $500,000 to somebody, you're going to have to report it to the IRS. So what that means is, by doing that gifting and expecting your other children to gift back to a child when they need it, you're cutting into what they could give to their own children, gift tax or estate tax free. So without getting too hyper technical into the tax issues, you basically have a certain amount you can give away at death or at life, so while you're alive. So while you're alive, basically think of it as the IRS is keeping sort of a ledger in the cloud somewhere, how much every time you've gifted away a certain amount of assets. And when you get to that magic amount, they're going to start taxing it. So again, most people with these very high exemption amounts we have right now aren't going to actually pay gift tax, but you're going to have to report it. And it is a different tax return. You're going to have to pay a CPA to do it. And even though it's a zero return, zero tax due, you do have to report it so that the IRS can kind of keep track of that. So this solution doesn't necessarily work. The other option is to give somebody that gift outright. So in other words, it vests, which again is a bad situation, which is what we're trying to avoid. And option 3, this is something that's relatively new and is very exciting, the ABLE accounts. I don't know if any of you are familiar with these, but it was the federal legislation, I want to say it was 2 or 3 years ago. It took a couple years for Missouri and most states to enact their own local enabling legislation. We finally have ABLE accounts in Missouri in 2017. In Missouri, I'm not as big of a fan as some other states. In Missouri, you have to do it online, and you can get like these gift cards, kind of credit card things. Some of the states, you can actually go in and open a bank account, which the whole idea of the ABLE accounts was to let someone who maybe couldn't own assets in their own name sort of have a more normal existence, get to do what other people get to do, and that is, I have my own bank account and I can spend some money how I want to spend it, which was really important for very high functioning people with disabilities. If someone can't speak, can't drive, can't feed themselves, well, that's a little bit different situation. But these ABLE accounts, I deal with families where they have very high functioning children that want to have some sense of normalcy, but yet they don't meet the definition of being, or they meet the definition of being either disabled or incompetent under the law, so that they can't really have money in their own name. So in other words, they have Social Security, but it goes into what's called a rep payee account, where someone else is doling it out for them. So this was a great vehicle where you can put up to like $14,000 and some change into these accounts per year. So in that example I just gave of somebody inheriting $30,000, that we could do. We could put 14 of it in an ABLE account, but then we've still got the other 14 plus that we've got to get rid of by the end of the month. So in this case, the $30,000 is actually how much we're putting in the trust. We're already fully funding an ABLE account. So I want to say that the inheritance was like $46,000 or something total. And I want to say it's 14,600, but don't quote me on that, what you could put in per year. So again, that is a way that you could give somebody that amount of money, but it could only be funded with that amount per year.
So where do you put the other part?
That is the $1 million question. So, well, here's, real quickly, we'll just go through. They have to, this is one of the few, for able accounts, I don't know why, they picked a different number. So 26, you could have this disabling condition before you're 26. Everything else is going to be 22 or 18. The disability has to be expected to last over a year, and there's only certain expenses you can take it out for. The legislation that set these up is under the same IRS code sections as 529 plans. So do you guys know what 529 plans are? They're where you can put away money for education for any beneficiary. They don't have to have a disability. And as long as you take it out for qualified educational expenses, you don't have to pay for the growth on the account. So if you put in $2,000 and by the time they go to college, it grows to 10, you've got that $8,000 of tax-free growth. It's win-win. You take it out for college funds. This is the same, but it has to be taken out for qualifying medical or living expenses. And the list of medical expenses that are qualified disability expenses are huge. So you could take it out for many, many things. There's very few things that you can't. I think, like I always say, it's kind of like the trip to Hawaii and the hot tub. Those kind of things probably not. But almost anything within reason we can usually get to meet the definition. And it's the same as a 529 plan. So you'd have to pay the tax plus a 10% penalty if you take it out for anything else. And there it's $14,000. Actually, it's indexed for inflation, so I think that has gone up slightly this year. Contributions are tax deductible, but for most people that doesn't make such a big deal. That's if a parent's putting it in. But this is something that an individual with a disability can put their own money into too, which is key. So that's in the case like I was talking about where somebody gets an inheritance. That's their own money. It's already vested in their name. So now they have this ABLE account they can put it into. And it can keep building. So if you got $14,000 a year, that's okay. But if you get up to certain amounts, for instance, you can't ever get over $445,000, which that would be a good problem to have, right? If you had $445,000 put aside for your child by the time they need it, that'd be great. But if they get over $100,000, most times if they're on SSI, that is going to knock them out of that resource. So, and again, which could impact their medical qualifications. So we'd want to always keep an eye on that. But here's the option for, and this is where like an estate planning attorney usually can come into play. Like I will give people all of the options and discuss other things. And a lot of times if we are talking about relatively small amounts of money, sometimes we can get rid of it in other ways. Buying things that we could legally, ethically spend down on. So maybe some adaptive devices, maybe some modifications to a home. There are things like that that we could do first. Because again, I kind of do a cost benefit analysis with my clients. Say they've got $30,000, but they know they're going to be using it relatively quickly. Then why waste the time and money of hiring an attorney to create this special trust for assets that probably are going to be gone in a year or two? As much as I'd like to take the fee from them and draft the trust, it's really not in their best interest. So at that point, we would talk about other spend down mechanisms, other things that we could do. Again, a lot of times it's modifications to the home, ramps. It could be either a van, a lift system, it could be a Hoyer lift, it could be a walk-in shower, it could be rails and things, or widening a hallway, or moving cabinets down so that they're wheelchair accessible, so that we don't have to move to a different home, that the place that we are now can be retrofitted. Sometimes that's more expensive than just starting from scratch, but we discuss all those options and get them to the places that they need to go. The other thing that we do often with folks is, as their child grows, sometimes the van that worked at the beginning doesn't work anymore. And what I've found, and not to pick on Children's Hospital, but it's just ironic to me that if you retrofit a van, you can't get into the parking lot here sometimes. But if you buy a new van that, and again, I don't know that much about vans, so don't hold me to this, but if they get a new van, they can. So I had one family, for instance, it was a personal injury settlement, so they had a couple $1 million with the Midwest Special Needs Trust, and those folks probably don't like me very well because I had 2 of these right in a row. And so within about 6 months, we had pulled like $6 million out of their coffers because they would not buy these families' vans. And I could not figure out why. I'm writing these letters, advocating for them. They'd already been writing letters, and they kept saying, no, we're not buying you a $55,000 van. They've got $3 million in this account. They wouldn't spend $55,000 on a van, but they would spend $25,000 to retrofit the van they had. Well, the understanding that I had from this is, well, that would be great, but like one of my clients, her daughter would have had to, because she had grown exponentially in a couple years, she was in that growth spurt preteen years, where she would have had to ride so slightly reclined, which made her felt like she was choking. So it was a very uncomfortable way to ride, first of all. Plus, with that van, they couldn't, and she had to come to Children's twice a week for something. I can't exactly remember what kind of treatment she was receiving. But her mom would have to literally drop her off, kind of leave her in the lobby, and then run and try to find parking on the street. And this is in the middle of winter, and I'm thinking, this is crazy. This person has $3 million. You're telling me you won't buy a $55,000 van? So again, those are the kind of things that we could talk about if you got an unexpected inheritance or something, how we could maybe quickly get rid of some funds if we needed to. But if we know that there's enough money or there's a reason to keep it, in other words, we don't need it now. You're doing okay, not that anybody can ever not use extra money, but say, you're a married couple, you're making ends meet, you're paying for all your child's need, and now your child has 30, 60, 100,000, whatever it is that they've inherited from somebody, or it's coming to them from someone's life insurance. Well, that would be good money to put in a special needs trust that we can manage for them. It would not be considered available to them if we do it in the correct manner for purposes of benefit qualification, and it wouldn't count against them as an available or countable resource. In addition, if the income is paid out correctly, it wouldn't be considered income to them under most benefit programs if it's paid out correctly, or it wouldn't be called what's called in-kind support and maintenance. So if any of you are on any of these programs, some of those terms may mean something. If they don't worry. You're lucky that you've never had to deal with it. If you do, at some point in the future, you'll get to know those rules really, really well. But what these trusts do is they allow for the assets to be held and used for that individual's sole benefit, but again, not counted against them per se. Now, there are 2 different kinds of trusts. So the one, for instance, I'm drafting tomorrow is going to be what's called a D4A trust. And that's a trust where it already vested in that person's name. So the person passed away, this check got written to their this child. Again, we put it sort of in a parking place. We parked it with the Emmaus Homes right now, and we're going to, as soon as we get this trust open, we're going to pour it over into there. It's a D4A trust, so that means if that person dies and there's still money in that trust, it has to be the state of Missouri or any state that provided governmental benefits will get paid back first, and the family members would get the inheritance after the fact. But if it's a third-party trust, that's where parents and grandparents and everybody come to someone like me ahead of time and say that if something happens to me, my trust sets up this special needs trust for this individual. Then there is no payback to the state of Missouri. So you can see why it's a big advantage to plan in advance. Because this crisis planning that I'm doing tomorrow, we're going to have to pay back the state of Missouri first. So then it's kind of one of those, it's dicey when you're thinking about making a trust distribution. Sometimes you wouldn't want to, but if you don't know how long someone's going to live, you don't want the state of Missouri to get it, so you're more likely to spend it. In a third-party trust, you could then keep it, and it could go back to your other children. It could go to, if your child with a disability has children in the future, it could go to their children. So doing it in advance gives you a lot of big options as far as governmental benefits planning. So did that kind of answer your question? So that's sort of the alternative is a trust. And that's really an able account, you're limited to the amount, so anything over that would have to go into a trust of some kind, or a spend down on, again, some medical or adaptive device or other things that are needed. So I know we don't have a lot of time, so I'm going to go through this really quickly, but this kind of talks about if you have a will or a trust, it could create the trust immediately. That's a trust that's in another trust or a will. So this is probably the least common way we do it when people come to us. It's called a springing trust, and the reason we don't use this as often, this works and it's okay, But there's a legal sort of nuance here, and that is if I have an IRA or if I have life insurance, can I really name that trust? Because it doesn't really exist yet. It's only created upon my death. So it's a springing trust. It arises at some point in the future. The beauty of that is I can amend it during my life anytime, and it's not funded, so it doesn't become irrevocable. And there's a lot of different reasons for that. You might have to change terms over your lifetime. You may decide who's going to be in charge of the purse strings over your lifetime. So if a trust becomes irrevocable or you can't amend it anymore, you're kind of stuck with who you picked 10 years ago. So there's some disadvantage to having a standalone trust. But the problem I see here is a lot of people anymore have IRAs. They have things that they need to name a beneficiary. And there's a legal sort of an issue there that some companies will take it as a beneficiary designation. Honestly, though, if you're a legal purist, I don't know that technically that's legally correct, and I would worry that even though, say, MetLife or someone took that beneficiary designation in the future, that they couldn't deny paying out to that beneficiary because it didn't exist. So this is probably the more common way we do it. We say, yeah, in my will or trust it says if I have, and again, I just use a simple example of 2 children, half my estate's going to go to child A, and the child B's share will go to a trust that I created at the same time I did my will or trust. Now, a lot of times if we keep that what's called a dry trust, so we don't put any money in it, then it can be amended throughout your lifetime, so it can be changed. So a lot of those, we draft them and they just sit on a shelf and nothing ever happens until later it's funded. But then we have a trust that legally exists that we can name as a beneficiary on life insurance or a qualified plan like an IRA. The reason this is, I use 50-50 just as an example, but I will say when I have families that have one family member, one child who may need more resources in the future, there's a lot of times that we are naming different percentages. So we may say 25% is going to go to the children that don't have a disabling condition, and maybe 75% is going to go to this child. Maybe not, and it just depends on how much resources you think it's going to take to keep that child in the community or provide for their medical or other needs that you are maybe providing while you're alive.
Can you do more than one SNT? Like, both of my kids are disabled.
Yeah, then you would definitely have separate, because the rules for those that they have to be for the sole benefit of. So you would never generally do a pooled trust. You would do a 2 separate trusts, but it could be created. They'd probably be mirror images unless the children's conditions were very different, because in those trusts too, we have some trusts, there's probably about 4 different ways I can draft those, but depending on the level of services or public governmental benefits we think that they will need. So in other words, you might have some that allow you to make disqualifying distributions if the trustee thinks that the benefit to paying it out outweighs the risk that you're going to lose a public governmental benefit. In some, we would prohibit those transactions completely because the risk is too great. So it depends how much discretion we want to give. So again, in those situations, it's when you're reading, especially because now I think my consumers, my clients, are so much more educated because you can get on the internet and you can research. And when you're doing that, and I would encourage all of you to do that, look into in special needs trust. That's going to be the term of art that you're going to find. Remember that there are 2 very different kinds of special needs trusts. There's third-party trust and there's first-party trust. So for instance, the one where it's vested in the disabled person or the person with the disability's name, that is their own money. It's their own money, so it's a first-party trust. You're going to have payback provisions. So in Missouri, we have D4A trusts, and we do have D4C trusts or pool trusts. We don't have, if you come across anything about Miller Trust, just ignore that. We don't have those in Missouri, but so sometimes that confuses people because there's a lot of stuff out on the internet. And that's another thing. Make sure when you're reading those rules, too, that you're determining, is that article that you're reading talking about the same kind of trust I'm talking about. So again, it's a good idea to educate yourself, but I think you always do want to talk to a lawyer who's well versed in this, because I will have people come to me that have done a lot of research, but the problem is everything they've read is about first-party trust or third-party trust, and we're talking about the other one, so then they're completely confused. So if you plan in advance, you're going to have a third-party trust, which is great. More flexibility. Don't have to pay back the state of Missouri. If you don't plan, we end up with the D4A trust. Or the other way you end up with a D4A trust is somebody has a car accident or something and has a personal injury settlement or something that you couldn't have planned for in advance. But generally, like if it's an inheritance or life insurance, you'd want to plan in advance. And again, I just wanted to touch on this. The other reason you do want to do documents is you don't want to, if you can avoid it, have to go to the court and get a guardian or conservatorship if that level of care would be needed. So in other words, if your child is going to turn 18 and they have a cognitive impairment generally and generally I say cognitive because you could have a physical impairment where you might need assistance, but it's not going to keep you from being legally competent to make your own decisions. In the state of Missouri and most states, you're going to have two different definitions. In Missouri, it's are you disabled or are you incapacitated? Disability is a finding for purposes of financial decisions, and incapacity is a finding for if you're in need of a guardian to make medical, educational, and living decisions. So if the child has the cognitive ability to create their own documents at age 18, we could do a simple power of attorney healthcare directive and avoid a guardian conservatorship completely. If they don't meet the legal standard necessary to create their own estate planning documents, then we're stuck going through this court process of a guardian conservatorship. So that's the kind of thing too where we sit down and a lot of times we'll have the clients go back to their doctor and say, does this person, and I'll give them, I kind of tell them, I have this letter I send that's, assuming that this is consistent with your medical opinion, because I never want to tell a doctor what to say, but either way they decide, it's not my business really. I just need it to say one thing or another, because I'll get something back that's, doesn't really meet the definition, but it doesn't say they don't. So then I go back, and you don't want that paper trail either, going back and forth to the doctor, like, did you mean this, did you mean that? So I kind of give them assuming that you think, and I kind of go on what the parents tell me. Like if the parents think that their child is high functioning, can make legal decisions, and want them to have that ability, then I write, you would only have a finding of incapacity and disability if, and I would cite the statutory language, because in a perfect world, we wouldn't want guardian and conservatorships for most of our folks. We do that sort of as a last resort. So again, a simple solution is just really, planning in advance. And again, it's never too early to plan, even if the planning would be more simplistic when your children are small and you don't know exactly what their needs are going to be. We could, lift restrictions later if we need them, but you can't put them in after the fact. So in other words, if you, become incompetent yourself, then it's too late. So, does anybody have any questions? Just out of curiosity, how many of you guys have a will?
We're starting.
Good. So it's one of those things, like I said, it's not fun planning to do, but everybody really should do it. So. Well, thank you for your time today. I appreciate it.